So if you're an inventor, one of the first big forks in the road you're going to hit is this. Should you file a provisional or a non-provisional patent application? And look, this isn't just about paperwork. It's a huge strategic decision that can really shape the future of your invention. Today, we're going to break it all down from the perspective of former patent examiners so you can make the absolute best call.
All right, here's our game plan. First, we'll look at the two main paths you can take. Then, we'll really dig into what a provisional actually gets you, and we'll expose a super common trap that a lot of inventors fall into. After that, we'll check out the direct route with a non-provisional, lay out a clear strategy for you to choose, and we'll wrap up with the one deadline you absolutely positively cannot miss. Let's jump in. So, let's talk about these two paths. Seriously, think of this moment as a critical strategic crossroads. The choice you make right now has major long-term consequences for your patent rights, your timeline, and yeah, your budget.
This is the question, right? Provisional or non-provisional first? Now, there's no single right answer that works for everybody, but I promise by the end of this, you're going to have a really clear framework to decide which path is the right one for your invention right now.
If you remember just one thing, make it this slide. It really boils down the core difference. A provisional application, it basically buys you time. Time to develop, time to find investors, time to test the market. But a non-provisional application, that's the direct path to getting actual enforceable protection. See the difference? One's a placeholder, the other is the main event.
Okay, so let's explore that first path a little deeper. What exactly does filing a provisional application buy you, and what are the strings attached?
All right, here's the formal definition. A provisional is really just a filing mechanism. It's how you get your foot in the door at the patent office. It does two main things. It establishes your priority date. That's the official date your invention is on record. And it lets you legally slap a patent pending label on your creation. But, and this is absolutely crucial, it is never examined. The patent office literally just files it away and starts a 12-month countdown clock. That's it.
And this table here really lays it all out, side by side. Just look at that provisional column. See all the no's? No examination, no formal claims required, and it can never become an issued patent all by itself. It just expires after 12 months. The non-provisional, on the other hand, is the complete opposite. It's the only application that gets you on the path to an actual 20-year patent.
And this is a point we really have to hammer home. You'll hear people throw around the term provisional patent all the time, but that's just not a thing. It's a provisional patent application. Now, this isn't just us being picky about words. It's a huge legal distinction. Having patent pending status is great, but you have zero, and I mean zero, enforceable rights until a non-provisional application is fully examined and granted as a patent.
Okay, now for what might be the single most important part of this whole explainer. Coming from our background as former examiners, we know this is where so many inventors get into serious trouble, the disclosure quality trap.
Just let that sink in for a second. A weak, bare-bones provisional that he threw together quickly, it's often worse than doing nothing at all. Why? Because it gives you this false sense of security. You think you've locked in your early filing date, but in reality, when an examiner finally looks at it a year or two later, that priority claim could be completely worthless.
So let me walk you through how this plays out in the real world. A year after your provisional, you file the full non-provisional. The examiner, me, pulls up both of your documents. They read a claim in your new application, then they scroll back to your old provisional and ask one simple question. Is there enough detail in here to support this claim? If the answer is no, if you added some cool new features in the last year that weren't in that original filing, then that claim doesn't get your early date. Nope, it gets the later date, which could be a disaster for your patent.
Because here's the kicker. The standard for an adequate disclosure in a provisional is the exact same high standard as for a full non-provisional application. You have to describe your invention in so much detail that someone else in your field could read it and know exactly how to make and use it. A sketch on the back of a napkin just isn't going to cut it if you want to lock in that early filing date.
All right, let's switch gears and talk about the second path. This is the direct route, filing a non-provisional application right from day one.
This is the real deal. This is the formal official request for the U.S. Patent and Trademark Office to actually examine your invention. It needs the whole package: a super detailed description, a set of formal legal claims that define your invention, and proper drawings. This is the only application that actually starts the process of getting you a real issued enforceable patent.
And here is the key strategic advantage of going direct.
Right now, the average wait time for an examiner to even pick up your application for the first time is somewhere around 22 to 26 months. That's a long time. By filing a non-provisional directly, you jump in that line a full year earlier. If your goal is to get an enforceable patent as fast as possible, this is a massive, massive advantage.
Okay, so we've looked at both paths, the pros and the cons. Now let's put it all together. Let's build a clear, simple framework so you can choose the right filing strategy for you.
First up, let's talk about the money. This chart gives you a quick snapshot of the government fees for filing a non-provisional. As you can see, what you pay depends on your size. A micro-entity, that's usually a solo inventor or a tiny startup, pays the least, around $400. A big corporation pays the most. And this table gives us a bit more detail from the 2026 fee schedule. Just look at that top row for provisional filing. It's a much lower upfront cost, right? The non-provisional fees, on the other hand, bundle together the filing, search, and examination fees, so they're significantly higher. And remember, these are just the government fees. Attorney costs are a whole separate thing.
So, when does filing a provisional first actually make sense? Here's your checklist. You should probably file a provisional if your invention is still a work in progress. Or maybe you've got a big trade show or an investor pitch coming up, and you need to get that patent pending status locked down quickly and cheaply to protect yourself. That's the perfect time for a provisional.
And on the flip side, when should you go straight to a non-provisional? Well, if your invention is totally finished and you're ready for examination, go for it. If you need that enforceable patent as fast as humanly possible, this is your route. And this is a big one. If you're filing a design patent for how a product looks, a non-provisional is your only choice.
Finally, let's cover the single most important rule if you decide to go the provisional route, and that is the non-negotiable, unmissable 12-month deadline.
You get exactly 12 months. That's it. There are no extensions, there are no excuses, and there are absolutely no exceptions. This timeline really shows you how unforgiving that deadline is. On day 1, you file your provisional and your priority date is set. Awesome. Day 365 is your absolute last chance to file the non-provisional. If you wake up on day 366 and you haven't filed, it's over. Your provisional has vanished into thin air and that early priority date is gone forever.
So I'll leave you with this final thought. The moment you file any application, a clock starts ticking. The real strategic question you need to ask yourself isn't just whether you should file, but whether the disclosure you're about to file is strong enough to make all that time and that all-important priority date actually count when it matters most.